and then you see the red button.
Yeah, okay. But so in the past, what's worked best?
Coming, everybody. Today it's my pleasure to introduce Adam Soliman, the director of the Fisheries Law Center and an adjunct professor of law here at UBC. Adam has a very interesting and diverse background. He started his career in the agriculture sector, working with family-operated businesses. And from this economic-focused research, he went to study law in Hong Kong as well as in the US, and then found the Fisheries Law Center here in Vancouver. Adam's interested in both law and economics of fisheries, and his research focuses on small-scale fisheries. He's advocating for access to justice of these often marginalized fisheries. He's currently teaching a fisheries law course here in UBC, and I've already heard some very positive feedback about it. And his talk today is giving us an introduction to fisheries law in general, as well as focus on property rights and fisheries management schemes. Thanks and welcome, Adam Soliman.
Thank you very much, Anna. Thank you for having me here. Okay, so as Anna said, we're going to be talking about two separated parts here. Just a quick intro to the discipline of fisheries law, and then we're going to move into property rights and have hopefully an interesting discussion after we finish that part. So I'm going to start with explaining what is that discipline, because a lot of people don't get a full grasp on it, and including mostly lawyers, that when you tell them fisheries law, say, what is that? Not that they don't know about the law, it's just they can't imagine the breadth of stuff that goes into it, and why is there a need for almost a big course on fisheries law. So one way to look at the study of fisheries law is to sort of segment it into different parts. Pre-harvest and post-harvest, for example. You've got management schemes, a study of management schemes, seafood regulations, aquaculture regulations. So in fisheries management, the stuff that we study in it, things related to the management schemes themselves, right? Community-based management schemes, ITQs, turfs, etc. And in that, we get into property rights, which we'll cover part of that today, and do comparative study between jurisdictions, compare other schemes outside of fisheries, and come up with lessons learned and modifications, suggestions for further development in fisheries management and management schemes. Another area is trade law, international trade law. And the reason why that becomes an important part in the study of fisheries law is that when you look at things or practices that you consider harmful or destructive to the environment and want to think something about it, one of the tools that are available, one of the legal tools that is available, is the use of international trade law or trade restrictions. And when you get into trade restrictions, you get into WTO challenges. So by looking at the case law that comes out of WTO and learning from them and seeing what happened there before, gives you an idea how can you discriminate against a product or impede trade for an environmentally friendly cause, or whatever cause you're supporting. It's not only environmental concerns that could be addressed under trade law. Sometimes abuse of crew could be used as one of the reasons you can restrict trade. So we study that stuff, and we get into arguments of how to achieve the goal by restricting certain products from entering your ports, for example. We get into governance. We look at human rights, the new human rights approach to fisheries management. How can you advance that? There's obviously an overlap with constitutional law in that arena. So we do those studies, we do comparative studies between jurisdictions on constitutional rights, whether it's Aboriginal rights in Canada, customary rights in India, in South Africa, in the US, how they're handling Aboriginal rights or native rights there. And we get out of that some ideas of changes that could be useful in different parts of the world. The study, of course, of IUU, which overlaps a little bit with criminal law, prosecutions and defenses, but it's much more than that. It gets into port state measures compliance. So that falls also under that part of management schemes. We look at international treaties and agreements, international law, the Law of the Sea Convention, the Straddling Stock Agreement, the Compliance Agreement, and we study those and try to make changes based on those international laws and the obligations of countries under those laws. Study of RFMOs, what can we learn there, what can we promote, what are the previous issues. Aboriginal customary rights, we study crew safety, which gets us into maritime law. Then we get into seafood regulations, post-harvest issues. And then over there we study food safety or seafood safety. Compare different laws in Canada, for example, with China, and study that whole arena of seafood safety. Labeling, very interesting. People think about labeling as just a label that you could put on seafood and that would be pretty much it. Funny enough, labeling gets us into constitutional challenges. What can you put on the label, what you cannot put. We get into freedom of speech arguments or commercial freedom of speech arguments. And believe it or not, it's usually pro-industry, not pro-consumer. So you get into those, and that study takes us into comparative stuff outside seafood and outside fisheries completely. Get into other food labels and what challenges happen in certain jurisdictions, and we do comparative constitutional challenges under the study of labeling. Then we get into another area for labeling, where it's what can you put and what you cannot put in that is not a constitutional issue at all. So we study all that stuff. Traceability, catch certificate programs, what certain jurisdictions have done, what succeeded, what didn't succeed, what can you do in a jurisdiction that you can't do in another jurisdiction. That becomes informative when you become part of a team that is trying to talk about traceability and what can be done, for example, locally in BC. Then you get into the whole area of aquaculture regulations. Then we study fish feed production, the regulations that govern fish feed production, raising actually the aquaculture itself, the fish itself, get into labeling of feed products. We get into seafood safety issue, human health issues that relate to aquacultures and the laws that govern that. So when that overlaps with a lot of areas that are what we call substantive law areas, gets to constitutional law, gets us into criminal law, it gets us an overlap with administrative law quite a bit as well. So environmental law, natural resource law. So it's literally a whole mix of everything together. That's what we call fisheries law. So if you try to define it, by all means, and please CC me on that because it's really hard. With that explanation, I can't really explain what is fisheries law and what's that study that we've been talking about. So, given that type of stuff, you'll be, I don't know if you'll be surprised or not, but fisheries law is not taught in a lot of law schools. As a matter of fact, it is taught in very few law schools in the world. In Canada, we have the one here in UBC. On the East Coast, there was attempts for one. In the US, I've not been able to crack one yet. In China, there is. But most jurisdictions don't have a course on fisheries law at all, which gets us into a problem, the access to justice problem. Now, if you don't teach fisheries law at law school, then, which is this gap here, how do you expect lawyers to advocate for fishers' rights or for whatever topic that we were just talking about? A huge gap in education, overlapping with a gap in advocacy because the tools that empowers those advocates are not there, the education itself. Now, I'm not saying there isn't anybody out there, but those are people that have probably been self-taught from practice. Nevertheless, there's a huge gap in that, in the skill set to do that kind of advocacy, supporting a coastal community, supporting an Aboriginal community in somewhere in part of the world with customary rights. And that gap is not in Canada, that's global. Now, because there isn't much education going on in law schools, there's also a huge gap in research, in legal fisheries research. Obviously, there's not a single publication on fisheries law journal. There isn't one. the stuff that comes out of legal scholarship is very limited. I know that as a fact because I search for it quite a bit, like constantly. So that's the trio, and that because of that creates an access to justice gap. And the studies of access to justice, they relate to education. It starts there. So keeping that in mind, that's one of the main drivers why the study of fisheries law becomes important as well. Okay, so I'm going to leave it at that with introducing fisheries law generally, and move on to the topic today, which is study of property rights. Okay, so general questions. And before I start this property rights section, please do not try to label me. I'm not on either side of the argument. I'm here just clarifying some terms. I get labeled quite often, and surprisingly on all campaigns. The object of today's presentation is simply clarifying some of the legal terms in property rights and relating those terms to some of the arguments out there, and specifically about ITQs. Now, some people, one question is, say, are cat shares or ITQs, are they property rights? Are they private property rights? Are they ownership? Are they something that you can own? There's a lot of, that question is posed quite a bit in literature. And also, does property right mean ownership? Or what is property right generally? Right? So these are some of the questions we'll try to answer today. Okay, so let's start with a very general categorization of property rights. There are different types. We've got state property or public property. That is property that is owned by the public. We've got common property or collective property, which is a property that is owned by a community or by a group collectively. It's not owned by an individual or an entity in itself. Which is what private property right is. Private property right is something that is owned by an individual. And then you've got open access property, which is really nothing, not here or there. But these are the main general categories of property rights. Okay, so the main theory in property rights says that property is a bundle of rights. It's a bunch of rights. And that individual rights within this bundle can be separated, transferred, removed, or added. It's whatever you attach to it. It's a bunch of rights. Now, several rights of property can be attached to a single good or a single property. The classic example is this, a house. You can own the house. It's a real property that you can own. Yet, you can have a mortgage on it, and that's a right of the bank on the property. That right is defined in the agreement that you would sign with them, what they can do and what they cannot do. It's also legislated by some things they can and cannot do. But you can also have a tenant, which is another right in the same property. Okay? And the list can go on. There's more than that. There's easements, which we'll talk about in the next slide. But you can also have a loan that is registered against that same property, or a charge. And these are all different rights that can be attached to the same thing that we're talking about. Ownership, the most extreme form of property right, is something that includes a set of rights. And these rights to the minimum would be the right to possess it, the right to manage it, and the right to control it. You also have the right to derive income from it and derive capital gains on the property that you own. You can transfer it while you're alive or on death, and it's protected at law. These are the minimum set of criteria that when we can say, oh yes, you own that thing. Now, what a lot of people overlook is that some ownership can also come with duties. The classic example is a firearm. You own a gun, does not mean you can do whatever you want with it.
Yes.
Yeah?
In the US.
In the US, that's right. But here in Canada, you have duties if you own a firearm. And they're different, obviously, from the duties in the US. You can't harm somebody with it just like that, right? And that just explains that, yes, if you own something, you might have duties with it. Also with property, like land as well, there could come duties with it. Now, proprietary interest, or the rights, can be obviously less than ownership. Ownership is the most extreme side of it. One distinction is between those property that can be, well, inherited properties that are either corporeal or incorporeal. These are, the difference is that the corporeal is basically real property, in the sense that it's something you can physically touch. But the other side, the incorporeal, these are creation of the mind. In that sense, they are a right of way, for example, or a right to drive profit. These are not something that you can hold in your hand. So that's one of the first distinctions of what is property rights generally. Real property here becomes land. Land includes the property on the land, so the house as well, and we refer to that as land. And that is a real property versus everything else which we call personal property. Now that distinction comes for many reasons. One of them is taxation, the other is inheritance, and a third difference between them is what can you do in court if that thing is taken away from you. So in real property, you have remedies available to you in court that is not the same as personal property. And it becomes, when people come and ask, for example, I want to litigate because of something that happened to the property, that becomes the first distinction that we have to make before we determine what is it that we can ask the court to do. A classic example is to give back the thing. That's usually something with real property. In personal property, quite often you ask for damages, you ask for compensation back. So that's the classic distinction between the two categories. Now, these proprietary interests, and the word interest here is interchangeable with the word right. Okay, so you can have right, for example, right to access something, or the right to exploit certain resources. That's a right, or an interest, a proprietary interest. Now, it's not a property in the sense that it's not something you can hold, so it falls under this category, and it's not real property. It's a right to have access to something and exploit certain resources. Another right that you can have is an easement. An easement is right of way. So in that same house that we talked about, I can ask you for, if you're the owner of the house, I can ask you for an easement so I can pass by in your backyard or in your driveway to access my land behind yours. That's where the example came from, is from farmland, where people wanted to access other lands, but the only way through is through another person's property. So that becomes an easement. Now, if you ask me then if you come and say, okay, I've got an easement, and ask me to explain what it is, the answer is I don't know what it is until I read the instrument that gave you that easement, meaning the document that stated what is the easement, because an easement is not like the other. Yes, you gave me a way to your backyard, but you might have qualified it. You might have said, I'm going to give you right of way to my backyard from 8 p.m. to 10 p.m. only. Another easement can say, I'm going to give you access to the front lawn only. So until you look at what is the instrument that gave you that right, you cannot understand what that easement is. You know the general concept, we're labeling it as an easement, but what is it really? Only until you read the instrument. Now the instrument can be a contract between you and I, that you gave me the right in it, and we write the terms and conditions on that piece of document, and we sign it, and quite often we can register it in the land title office. Or it could be a statutory right of easement, meaning that the government issued me that right, so I can go back to the legislation that gave me that right to understand what are the terms and conditions of that easement. It could also be found by court. And that's sort of a constructive easement in the sense that you've been giving me that access to my land for 25 years. Today you want to stop it. I can go to the court and say, you've given me easement for over that time, and because of that I've done X, Y, and Z, and the court can find that there is an easement, right? That's not written, that's not in statutory law, that's in case law, in what the court gave you. And quite often the court would determine the terms and conditions of that easement. So again, back to that one simple term called easement, which is very well defined as right of way. What is it? We don't know until we look at the instrument. Now, another right, and we'll come back to that when we talk about ITQs. The profit of prendra is basically a right to drive profit. That's what it is, a right to drive profit. Another instrument that falls under this proprietary interest is licenses, which is a permit to do something, or even to do a trade. And there are different types of licenses. Driver license, right? But if you want to categorize them, there's bare licenses, there's contractual licenses, there's something called license by proprietary estoppel, which is similar to the situation where I described to you. If you give me right to way for many years and you want to stop that suddenly, you can go get works out the same for license. It's license, I have it because you did something and maybe do something based on that kind of promise. So you'd be found to have a license by proprietary estoppel, which means that you're stopped from preventing me from going there because of what you've told me before and what you made me do. And there's a license coupled with an interest. Now, interest is interchangeable with right, so what this is, it's a license plus a right to do something. Now, our case law in Canada on ITQs said that an ITQ is a license coupled with an interest, which is a license coupled with this interest, the interest to drive profit. That's what the court described ITQs to be. Now, going back to ITQ itself, the individual transferable quota, the transferability here is just a right. You have the right, by holding that quota, to transfer that quota to somebody. But the right that you have, at least for the way ITQs have been managed so far, is an unqualified right, meaning that it gives you the market-based system to transfer it wherever you want, or whomever you want. But the question becomes, is that the only way it could be? Could we put restrictions on the right to transfer ITQs? The answer in law is yes, nothing prevents us. The instrument is there. A right can be qualified. The right can be qualified to different groups. You can give a Class A transferability or Class A ITQ that gives a right to transfer to anyone, but Class B is restricted to a certain community. Those instruments are available because once you understand what those rights are doing and that it's a bundle of rights that you can attach, you can play around. It's like mixing and matching. Unfortunately, the way that we have ITQs so far is that transferability is unlimited, which led to the whole issue about criticism on ITQs, which we'll get back to later in a second here. So property rights may exist with regards to quotas, but it's far from unlimited. It's not a complete right. What are some of the general restrictions in most jurisdictions? Is states can restrict and limit the entitlement to protect natural resources. We've seen that here in Canada, in BC, in the case of Malcolm, or the ITQs in halibut, which we'll discuss in a bit. States generally wish to be able to revoke or reduce the harvest, that kind of right. States expressly state in some states expressly state in their legislation that ITQs is not property, and some actually refer to it as a privilege. Now, the word privilege, which it came up in quite a bit of case law on ITQs, is basically another interchangeable word with the word right. Okay, so it's a privilege. It's not a property. It's a right. That's what it is. It's a right to do something, and the right was specified in some case law as the right to drive profit. So that's the word privilege. Because privilege is not a classic legal term, but it's synonymous with the word right. For some reason, they chose that word in some of the case law, but that's what it is. Now, also, property in fish itself historically has been found to be a public property. And because of that, there's the idea of the public trust doctrine, which means that the governments that manage a stock or a fish stock that is a property, a common property or public property, is a trustee on that property. Trustee means that it's holding that stock in trust or managing that stock in trust for the public benefit, which is why some states maintain the right to revoke or reduce the harvesting right. It's driven from that theory or from that historical understanding. Now, in the US, for example, their Fisheries Act there had modified the act to allow for ITQs, and that's why they have specified that ITQs is not full property because of that mandate that they have. Okay? Now, so these are some of the terms. I'm going to go now to some of the criticisms of ITQs and not defending the criticism, not arguing for or against the criticism, but clarifying also some of the terms that were used in the criticism of ITQ to shed some light on some misunderstanding and the use of some of those terms. Oh, before I do that, it's also important to have this main distinction between jurisdictions, right? In Canada, we're a common law jurisdiction. The US is common law, the UK is common law, and Australia, New Zealand, and very few others. The rest of the world is civil law. And the difference here is that the law in those civil jurisdictions is written. You can go to the text of the law to find answers to your legal questions. What is ITQ? You'll find it written there. In common law, we refer to it as judge-made law. There are some codification, there are some written texts. So in Canada, we have those laws that are written that we can go to. One example is the Fisheries Act. But it doesn't have everything. So we have to resort to case law. And basically in the case law, or the text of the cases that goes through the court, the judges interpret whatever law is there, plus old principles that were made by the courts to interpret and answer your questions. So if you're looking for answers on a legal question, one source, yes, is to go there into the text of the law to see what's said there, but it's completely incomplete if you don't go and review the case law to determine what they are. So a lot of those rights that we explained before, they're not creatures of legislation. They've been developed by case law over the years, primarily out of the UK. Most of the common law duties, like the stuff about the firearm or a duty of care, these are creatures of the court. They're not written laws. A lot of the stuff about easements, they're creatures of the case law, not about written law. In civil law, judges can't make that interpretation, just application of law and fact. In Canada, the judges interpret, and that becomes law. Okay? So, let's go now to some case law in Canada that came on ITQ. We only have two case laws in Canada. We have Soliman versus Royal Bank of Canada, which is a Supreme Court of Canada case. And because it's a Supreme Court of Canada case, it takes jurisdiction over all Canadian provinces, so it becomes law. And the only court that can make changes to whatever's stated there is the Supreme Court of Canada itself. And in this case, all what they said is that that fishing license or a license coupled with a proprietary interest, a right. That's what it is. They define what ITQ is to be this. That's just a license coupled with a proprietary interest, which is far from what people refer to as ownership or even real property. They looked at interesting discussion about commercial they looked at the commercial value of it, and they determined something very interesting. They said, because the issue here was between private parties, not between government and an individual about what is ITQ, we will give it some property rights element because of the major commercial value in it, and hence we look at it as sort of a property just within the limited interpretation of the Banking and Insolvency Act. And that was the first case that we had in Canada. And because of that, a lot of people expected that ITQ is property, and it's such a strong property that nobody can change it, including the minister. Although the Act was clear on that. And then came the other recent development here in BC on the halibut ITQ, where 3% was transferred ad hoc from the commercial to the recreational fishers. And then the commercial fishers went to court, and it was appealed as well. And they tried several attempts to say, well, the minister doesn't have that right to make that change. And this case said, no, actually the minister does have that right. The minister can change the quota, and it's in his discretion. So they argued, did he abuse that discretion? And the court answer said, no, he did not abuse that discretion. And because of that case, they assured that it's a privilege, it's a right, again, but it could be revoked without compensation. And that is important, without compensation. And I'll touch back on that in a couple of slides. Why is this important? Now, before I move on to some of the criticisms, cover one more case just to brainstorm of limitations and expansion of what you can do with those kind of various rights. We have in Canada a very interesting type of property rights. I don't see it in any other jurisdiction. It's primarily a Canadian invention, which relates to Aboriginal title. In this case, the court determined that the Aboriginal title is a special type of title. It's a special case. And in that, they said that the differences between native and non-native titles. A native title, the use of that title, the use of that land, must not be irreconcilable with the nature of attachment to the land, in the sense that the reason why you got the title, the specific use of that land, it's tied into your entitlement to that land. So if you got it for one purpose, you have to have it for that purpose. The other difference is that it's alienable only to the Crown. You can't sell it to the public. You can only sell it to somebody internal from that community, or if you want to sell it to outsiders, you have to sell it to the Crown first, the state. And the reason why they said it's the state is because they also held that the state owes them a fiduciary duty, which is a very interesting development as well, but it's not important for our discussion here. But this title can only be held by a community, and it's constitutionally protected. And it's constitutionally protected because the government's duty to Aboriginal people. So I'm referring to this because I'm just trying to explain that what you do with those rights, there's room for innovation, there's room for changes, and there are lessons to be learned from that example. So I just want to switch quickly to some of those social concerns about ITQ. One of the main criticism about ITQ is the initial offering, that ITQ was offered for free to the fishermen, which raises concern for the public's right. Why are we giving our fish free to certain fishermen that turn around and sell that quota for millions of dollars? Well, that's understandable, but there's one element that I would like to clarify in that argument, that if the government had charged money for that initial offering, they cannot revoke without compensation. They would have to then compensate back. And when they compensate, they have to compensate on a fair value, which is today's value. right? So that's one argument, or one issue that is often neglected with the criticism of the initial free allocation. So keep that in mind, because that's important. And if it wasn't for this free initial allocation, the court in Malcolm would have not said what it said, that the government can revoke without compensation. And keep in mind that the real instrument in law is actually the license, the fishing license. Quota is just a right. And the license, they charge for it. And that's renewable. So when we come and start thinking of other alternatives, like Professor Bromley, when he suggests annual auctioning, well, that's fine, but in that sense, it's limited to a specific duration, which is the year or the 2 year or whatever season you're going to auction it for. And that allows you to drive income or charge people, and the factor of compensation becomes minimized because you're not really capitalizing a lot of money into it that the government has to compensate down the road 15 years into millions of dollars. But if it was not a short-term allocation, in the sense that the way it is, then you've got to be careful if we suggest charging money for it. The other argument is armchair fishing, which is one of the concerns of ITQs and raised by Professor Pinkerton. Well, that's fine. Armchair fishing is, it's basically because the rights attached to ITQs allow people to be able to transfer it or lease it out, and it does not qualify that right by a restriction. Now, one of the solutions to that is to couple it with owner-operator, which is the scheme out east. Nothing prevents adding that restriction to the transferability right that was given with ITQ. So if you're thinking of changes to deal with one of the consequences that emerged, think about that. There's nothing preventing. It's not either or. We don't have to dismantle the scheme and move to an owner-operator to deal with armchair fishing. We can just add that right to it. Economic impact on coastal communities. Well, the issue of coastal communities and the idea of transferability and taking employment away from it can be dealt also with some restrictions to the transferability, in the sense that you could restrict the right or have different classes of transferability. You can allocate to a community and restrict that right from being transferred outside of that community. And if you think back to the example that I referred to with Aboriginal title, that's where the lessons are coming from. You can restrict that. It could be remain with that community and only with that community. Now you can get into very creative rights as well. You can add a territorial use right to that ITQ transferability as well, in the sense that not only that I'm going to give you that right for the community, and it's going to be held in communal property in the sense that the organization is going to hold it collectively for the benefit of its member, I can also give you a territorial right to be able to use that ITQ in and exclude others. Industry concentration, that brings us obviously to the main objection on transferability, and that can be dealt with again in some of the rights, but it goes beyond that. This is where it gets us into antitrust or anti-competition legislation, and unfortunately that legislation in Canada is pretty weak, and it needs to be developed. So to deal with that kind of issue, it could be within the scheme itself, the redesign or the new design of an ITQ scheme that addresses that, or it can come out from a completely different area, which is our development of our anti-competition law in Canada. Now, I'm going to stop here. I wanted to take you to an example in Alaska where they have community quota entities where they set up this not-for-profit organization to support certain communities, and they can get ITQs. Unfortunately, they have to buy it, but they hold it communal and they distribute it to members of their community. And there's only 2 places that have done it, and the most developed one is Old Harbor, which I had some information on here, which I've visited and done research on. But the purpose of that presentation, of that part, was to showcase one example of how an intervention an existing ITQ took place. That intervention was in the halibut and sablefish fishery in Alaska. They asked those communities to develop a not-for-profit organization, and if they do that, they have the right to purchase ITQ at market price, which sounds to be very funny because, thank you very much, what are you giving us here? Nothing. But the fact is that they actually give them free licenses to fish other types of fish, and they promote the new entrants within their community. So it's much more than just go by your own quotas. And I wanted to explain that and show you some of the comments on this case study. This is what Old Harbor is. It's on Kodiak Island in a very isolated area, 200 people that live there. They are quite happy with that example. They're satisfied with it, they have hopes for it, but their situation is a bit unique in the sense of the timing that they bought and the price they bought it. So I'm going to stop here, and I'll take your questions, and please bring on some of those sensitive questions about property rights, and if you feel strongly one way or another, please throw it in. Okay. Sure.
Any students?
Yes. Thanks.
You didn't really get to the labeling stuff, but at the very beginning you mentioned how freedom of speech has
Yes.
been used in cases where everyone's involved.
Yeah.
Could you perhaps a brief example of what that means?
The brief example in the US on RBST, the hormone that they use to raise cattle, to get milk out of cattle. Some farmers try to label it and say it's RBST free. Okay, it's a good thing, right? They're stopping the use of the hormone that a lot of people suspect to be harmful. They were challenged by the industry, and the court held that they actually cannot advertise that because it puts an impression that RBST is harmful, and they don't have evidence to prove that it's harmful. Now, put in mind that the US have this libertarian approach to food safety, in the sense that, okay, do whatever you want until somebody proves it's harmful, which is quite opposite from the other approach, which is the precaution approach. Before you do something, prove that it's okay. So because of that, they were not able to do this. So in that sense, it was a constitutional challenge, and the other said it impedes our freedom, commercial freedom of speech, and and it's actually, you think about it, they're actually preventing the others from their speech, but they used that argument, they were successful. So you learn from those examples, and I've done, for example, a paper on that, and I compared it to the salmon, the GMO salmon, which the labeling was okay, but there was some challenge. They had to overcome the exact same constitutional challenge and the legal test that was developed in that dairy case. That's possible.
So the student has spoken. I can. This is just a comment. I like that very much that you presented, because you presented the case that this is like an onion with lots of layers.
Yes.
And the discussion in the international literature is dominated by, has been a long time by some Scandinavian, let's call them absolutists, who says ITQ are an absolute right that's protected by the Constitution, and everybody else is a communist. And I have been in discussion where Anason, the
Yes.
fanatic, really from Iceland, has presented this view.
Yes.
And it has become almost impossible in these circles to actually meet, to actually show, to actually argue that ITQs can be qualified. And this, I like your presentation very much, because it shows that it can be legally, and it ought to be, because it's not an absolute right.
Thank you very much, Professor Wally. You're absolutely right. The absolute rights are very limited. Our right to freedom of expression in Canada is not absolute. Right? We think it's absolute. It's not. It's qualified. You can't defame somebody, for example. Right? There's qualifications, even with those very important constitutional rights. Now, property right doesn't go even near there. So it's certainly a bunch of layers. Plus, ITQ is different in every jurisdiction. It depends on what the case law in that jurisdiction says. It's sort of, each jurisdiction is taking life on its own for what ITQs mean. And don't be surprised that it could mean two opposite things in two jurisdictions. Right? It's because the idea of common law, that the courts interfere and make their opinion, make law based on what they're asked, which is different than the courts in Iceland. And the courts here are not binding on Iceland, nor the Iceland cases are binding here. So they mean different thing, and they're way far from complete property rights at all. Yes.
It's interesting that you brought up free speech because it's true the legislation protecting freedom of speech here in Canada is much weaker than it is in the United States. It's a whole different ballgame. But this reminded me of something. I remember my supervisor, Tony Pitcher, and Mimi Lamb, they were talking quite often about how access to fisheries, to fishing, should really be treated as a privilege rather than a right. And they were saying that within an ethical framework, at least, I don't know how that would be enshrined in law, but within an ethical framework, a privilege differs from a right by the fact that it is not inalienable. They were saying that a right is something like to freedom of speech, for example, or to equality before the law, etc., etc. This is an inalienable right. This is intrinsic to the system, whereas privilege can be revoked. They were using examples like the right to driver's license. It's to be revoked if the rules by which it's governed are violated. So I'm just wondering what you think of that approach, this right versus privilege distinction.
It's an academic distinction. From legal distinction, they're the same in the sense that even rights can be revoked. There are different types of right. There's an absolute right, a constitutionally protected absolute right, and that when you get into those, this is the right to life, for example. That literally it's going to end there. Everything else becomes non-absolute, constitutionally protected right, the most important freedom of speech and all that. There's second category, second class rights, if you will, and they could be qualified, freedom of speech, defamation, you can't defame somebody. So that distinction between rights and privilege, that they can be revoked and not revoked, is not factually true in law. A right can be revoked. I can give you a right to access my land, and I can revoke it. Without even you agreeing, I can revoke it and you can go to court and sue me. And maybe I'll win too because I have a reason or defense. So the rights can be revoked, absolutely. And the whole distinction between privileges and right, it's easier in law to look at it as almost the same thing. A privilege is not a lesser type of right. It all depends on what are the details of that right or privilege, right? And where's the source of it and what are the protections afforded to that right.
I know there's much more questions, I'm sorry, we ran out of time. Adam is on campus, he's around, so please approach him, send him an email, or just have a chat with him just after.
Yeah, I'm going to be standing outside for a bit too.
Yeah, so just approach him just now. There's your class coming in, so unfortunately. Thank you.
Thank you for coming.